Hong Kong's new Security of Payment Ordinance lets contractors demand timely payments, boosting cash flow and allowing work suspension for delays. Here to talk about this are Stanley Law from Deacons and Donovan Ferguson from King & Wood Mallesons, Hong Kong. Starting with Stanley, what exactly does the Security of Payment Ordinance address in the construction industry?
Firstly, the ordinance tackles the problem of delayed payments. It mandates payment timelines to ensure prompt payment to contractors, subcontractors, suppliers, and consultants. The ordinance reduces financial strains and project delays, allowing contractors, subcontractors alike to manage their finances more effectively. The ordinance also introduces a dispute resolution mechanism. It establishes a swift adjudication process for resolving payment disputes, which helps avoid lengthy arbitration or litigation. Adjudication aims at resolving a payment dispute within 55 working days from the notice of a statutory claim. Furthermore, the ordinance addresses conditional payments. It renders paid if paid or pay when paid clauses unenforceable, ensuring that contractors, subcontractors alike are paid for completed works, regardless of whether the payer has received payment from their clients. Finally, the ordinance provides mechanisms for the enforcement of determinations. It involves the district court and the court of first instance to ensure that adjudicators' determinations are upheld and respected. This strengthens the reliability and effectiveness of the adjudication process.
After more than 20 years, Hong Kong now has a statutory right to adjudicate claims for additional payment under construction contracts. What this means is that each month, main contractors, subcontractors, and suppliers can dispute how much they think they should be paid and refer that to an independent third-party adjudicator. That adjudicator will consider the claim and decide how much that person should be paid. That decision is going to be binding on an interim basis unless one of the parties refers it to arbitration or litigation. That adjudicator's decision will be enforceable as if it were a judgment of a Hong Kong court. This is a significant development for Hong Kong. It brings Hong Kong into line with other jurisdictions like Singapore, Malaysia, and Australia. It's going to help cash flow in the construction industry and hopefully reduce insolvencies, which has been and continues to be a significant challenge for the industry.
But overall, who will be most affected by it?
The whole construction industry is going to be impacted and assessed and affected. Subject to some monetary thresholds and some limited exceptions, it applies equally. So from August this year, everyone's going to have to get ready to comply with this new law. My personal view is that it's going to be the main contractors who are likely to be impacted the most. There's two reasons for this. The first is that main contractors are the party that's most likely to receive the most number of payment claims each month. The second and bigger reason, though, is that the ordinance now prohibits pay when paid provisions. Now, what these provisions are a clause in most construction contracts that says main contractors only have to pay their subcontractors when they receive payment from their clients, so they were never out of pocket. Those provisions are now void and unenforceable, and main contractors are going to have to pay regardless of whether they've received payment from their clients.
The contractors, subcontractors, etc., will be among the most affected. They will need to revise their contract terms, update their payment regimes, train their staff on the new requirements. Additionally, they must improve their document management system to comply with the tight time frames under the adjudication procedures. Project owners and developers must ensure that the contract complies with the Security of Payment Ordinance. They will need to prepare for efficient and timely payment schedules to adhere to the new legislations. Legal and compliance team will also bear a significant impact. They should review and update standard contracts and provide training on the new adjudication process. Next, we have the adjudicator nominating bodies, or called the ANBs. Under this new ordinance, further ANBs may be expected to be registered. These ANBs are responsible for ensuring that adjudicators are registered, trained, and ready to handle adjudication cases. Lastly, construction industry associations like the Hong Kong International Arbitration Center, the Institute of Surveyors, Institute of Engineers, Institute of Architects will play a crucial role. They can provide guidance, resources, and training sessions to help their members comply with the new legislation and be registered under their respective panels of adjudicators.
Now, looking at both the pros and cons, what challenges could arise in implementing the ordinance?
Standard contracts will need significant revision to incorporate the Security of Payment Ordinance, which could be both time-consuming and costly. This process requires meticulous attention to details to ensure that all necessary changes are made accurately and effectively. Another challenge is the availability of adjudicator I've just mentioned. To handle dispute properly, it is essential to have sufficient qualified adjudicators available. The transition period from old practices to new requirements will also pose challenges. Managing this transition without causing project delays will require careful planning and coordination. And finally, the most important part, in my view, the enforcement of the ordinance. This will be very critical. Effective monitoring and enforcement mechanism must be put in place to ensure compliance across the industry. This will involve legal proceedings to ensure compliance with the ordinance and the award of damages to those who do not receive their payment to uphold the integrity of the ordinance. Also, those who do not receive their payments are allowed under the legislation to suspend their work or reduce the rate of the progress of their work, and all delays will be responsible by the payers.
In the past, one of the problems has been that there's a clause in most contracts that says you can't refer a dispute to arbitration or litigation until the project completes. That can sometimes be 3, 4, or 5 years after you sign the contract. So in effect, main contractors and subcontractors had no way of getting a relief or getting a remedy. That goes out the door with security of payment, and it changes completely because you now have a monthly right to refer matters to adjudication. The biggest challenge I see is that we're going to have to change the way that Hong Kong approaches claims. We're going to have to change the mindset and the attitude of most people in the construction industry, because traditionally, these issues were left for the end of the job. Now they're going to have to be dealt with on a monthly basis. So this means that all parties are going to have to properly keep records. They're going to have to make proper payment claims with substantiation and evidence. And those who receive those payment claims are going to have to fairly certify them and pay those claims in a much timely manner.
Thank you so much for sharing your insights, Stanley and Donovan.
Thank you.
Once again, those were Stanley Law Counsel at Deacons and Donovan Ferguson, partner at King & Wood Mallisons, Hong Kong. For more news, visit hongkongbusiness.hk.